So Chris, you're a partner in the dispute resolution team here at Brabner's. Presumably you're experienced in ADR and mediation. So tell us what is mediation, what is ADR?
Well, when we talk about alternative dispute resolution or ADR, we're referring to the different mechanisms or processes that parties to a dispute can engage in as an alternative to the traditional route of litigation before the courts and having their dispute determined at a final hearing by a judge.
And what are the benefits of that?
Well, they are numerous, the different benefits. There is often a significant cost saving. The different ADR mechanisms can offer flexibility to the parties, control to the parties, confidentiality to the parties, and often a better chance of preserving existing relationships before they become too stressed by the rigours of a difficult court process.
What are the different types of ADR that clients might want to consider?
Well, they can be non-binding forms of ADR, or they can be binding forms of ADR. In the non-binding forms of ADR, typically you see something as loose a concept as straightforward negotiations, parties engaging with each other, or something more structured like a mediation or an early neutral evaluation. Some binding forms of ADR would include arbitration, adjudication, or expert determination.
And has the court got the power to compel ADR?
Yes, the court can, if sees fit to, use its case management powers to order the parties to engage in ADR and a specific form of ADR, perhaps mediation, and to stay any court proceedings to facilitate that ADR taking place. Historically, the courts have been very keen to encourage parties to engage in mediation and are also able to impose cost sanctions on parties that unreasonably refuse to consider ADR.
And what are the risks if you refuse ADR?
Well, as I say, you can be sanctioned by the courts in terms of costs. So perhaps regardless even of the outcome of your eventual dispute, if it's felt that you unreasonably refuse to consider ADR, you may be sanctioned in terms of additional cost liabilities.
Tell us about mediation. What does mediation involve?
Mediation involves the appointment of a neutral individual as mediator by the parties. That individual is there to act as a facilitator between the parties, to encourage them to find common ground and explore options for settlement of their dispute. The individual, the mediator, doesn't act as a decision maker or in a judicial capacity in relation to the dispute, but is as I say, a facilitator between the parties to encourage settlement.
Is the mediator usually a lawyer?
Typically, the mediator is or has been a lawyer for a substantial period of time, whether they've practiced as a solicitor or as a barrister.
What type of cases are most suitable for mediation?
Most cases generally should be considered as being potentially suitable for mediation. In cases where there are some specific requirements of the parties, for example, they might need an injunction to compel somebody to stop them from doing something or to do something, or where there is need for a particular precedent in a legal judgment, mediation might not be appropriate. But in most of the cases where a settlement would be beneficial to the parties, mediation tends to be something worth considering.
In your experience, do mediations have good prospects of success, good chance of reaching a settlement for the clients?
Yes, they do. The majority of cases that are referred to a mediation result in a settlement, whether at that mediation or shortly following the mediation. And that can often happen where the issues have been narrowed or the parties have been brought very close together during the mediation but not quite agreed a deal on the day, but very shortly afterwards they might conclude that settlement.
And any tips for how to get a good deal out of mediation?
Well, go prepared, and go with a lot of patience. It tends to be a process that lasts a day, and it can often be a long day, but go well prepared with all the information, not just regarding your case, but I think regarding your general sort of future intentions, because solutions at mediation can often be creative and involve things that aren't necessarily within the scope of the litigation, such as future business relationships or perhaps other unresolved issues that sit outside the context of the particular dispute that's before the courts.
What makes a good mediator in your view?
I tend to find that those mediators who can come up with some creative solutions or creative points of view that perhaps the parties haven't necessarily previously anticipated tend to be the most sought after mediators.
How are mediators chosen and agreed?
Well, it's a consensual process, mediation. So the mediator has to be agreed between the parties. In certain circumstances, there may be an agreement between the parties or a direction from the court that if they can't agree the mediator, there will be a particular mechanism for somebody independent to be appointed. But in the vast majority of cases, the parties will agree upon who the mediator will be.
And what are the benefits to a client of going through the mediation process?
It often, in many pieces of litigation, offers them the best chance of settling their dispute at a sensible point and a sensible level before perhaps costs become a bar to settling disputes. But generally speaking, the advantages are that engaging in mediation, it's non-binding. So, if you can't reach an agreement on the day, you haven't necessarily lost anything other than the time and costs you've put into the mediation. It's confidential. So anything you say or any concessions you make at the mediation can't be used to prejudice your future legal case if no settlement is reached. So Helen, what's your experience of mediation been, and have you found that there's a particularly opportune time for parties to engage in mediation?
The best time to mediate does depend on the facts of the case. Generally, it's something that's worth considering early before costs start to escalate. But there are some cases where our clients feel they're not able to mediate early because, for example, they need to see full disclosure from the other party before they can really understand the merits of their case. There are other cases where we're unable to get to mediation until right before trial. So it does depend on the facts of the case, but generally I think it's something that you should consider from the very outset. So in your experience, Chris, does mediation stand a good prospect of resolving a dispute?
Yes, the majority of cases that are referred to mediation by the parties will result in a settlement either at the mediation or shortly afterwards, as a result of the parties having effectively narrowed the issues during their mediation or gone a long way towards each other in terms of reaching a common ground for settlement. We do see it commonly that matters might not settle on the day of the mediation, but in the days or weeks following, they do. But mediation is not the only form of ADR. ADR is not a one-size-fits-all. There are lots of different forms of ADR, some of them non-binding, some of them binding, and parties can avail themselves of a whole range of mechanisms via ADR to suit their dispute and to suit the timing of when a settlement or a conclusion or to the matter might be appropriate. And are there other forms of ADR which you found useful in resolving disputes?
One form of ADR we found useful quite recently is the court's early neutral evaluation process. That's a semi-judicial process that some courts offer, particularly at the county court level, where a district judge or a high court judge will look at the papers early on and give an initial view before trial. That's done on a without prejudice basis, so the judge that ultimately decides the case won't know what's been said. But we found that process very, very useful at giving the clients and the other party an early indication of what the judge at trial might think. And unsurprisingly, once you get that view, parties have invariably settled straight away. So it's a very, very useful process that we found very helpful to our clients, particularly where there's a very difficult party on the other side who isn't coming to the negotiating table.
So are there any other common forms of ADR that perhaps provide the parties with a binding mechanism?
Quite often we deal with arbitration procedures, which are very different to litigation. That tends to be something that the parties have contractually agreed in advance. Those arbitration procedures can be quite different. So say from a very high value international arbitration out of the ICC to smaller arbitration procedures. They give the clients a lot more control over the process. They can be cheaper depending on the type of arbitration used. But they do create a binding decision when it's a very different process to mediation, which is voluntary and it's very much in the hands of the parties as to what the ultimate outcome is. Arbitration, you're putting the decision into the hands of an arbitrator, and so you will be contractually bound to that decision.
And what are the key advantages of arbitration that you think parties who are agreeing to refer their disputes to arbitration rather than court proceedings, what are those key advantages that they're seeking to secure?
One of the main attractions of arbitration is confidentiality. That's why we see arbitration clauses in a lot of high-value contracts, because the parties want to keep the outcome of their dispute and indeed the existence of their dispute entirely confidential, whereas the court process is a public process that can lead to bad publicity, for example.
I know colleagues of mine have been involved in other forms of binding ADR, such as adjudication. Can you explain a little what's involved there and where that applies?
You often see adjudication in the construction arena, but we do also use adjudication in standard commercial disputes. That might be where you appoint a third-party adjudicator to come in and give you an evaluation of your dispute on a contractually binding basis. So there are cost savings to that process if it can be agreed. So Chris, are there any other forms of ADR, particularly binding ADR processes that you see regularly?
Yeah, we regularly see contracts which provide for expert determination of a particular issue that might be in dispute between the parties. Expert determination will involve the appointment of, well, an independent expert, typically to consider a particular and quite narrow technical issue. For example, the value of a particular asset. The expert is there as a decision maker as to that technical issue rather than acting in a judicial capacity. Those disputes over those issues are suited to expert determination when there isn't a wider dispute over facts and legal issues. And that's a very effective way of resolving disputes over technical issues.
And presumably there are big cost savings to that as opposed to going through a litigation process.
Absolutely. The expert's decision on the issue that's referred to him is contractually binding upon the parties in accordance with their agreement to refer the matter to expert determination, and can save an awful lot of money in terms of having that issue determined by the court, which would commonly require both parties to have their own experts appointed and for the two experts to engage in some sort of joint process to resolve the issue.
And do you agree that we're starting to see those types of clauses, whether it be a requirement for expert determination or even a requirement that parties mediate before they litigate within commercial contracts?
Yeah, commonly commercial contracts will have an escalation provision in them, which will require parties to engage in some form of negotiation with each other, perhaps at an operational level and then perhaps at a very senior level within the respective businesses, followed perhaps then by a requirement to mediate if there still is no settlement, and only once a mediation has been unsuccessful might they refer it to court proceedings. And if the parties don't comply with that, the courts have the ability to stay any court proceedings until the parties have complied with that escalation or dispute resolution clause in their contract.
So thanks, Chris. That's some really interesting material, and sounds like mediation ADR are great options for clients.
Yeah, clients have got a whole range of options and mechanisms available to them, depending on the nature of any dispute they're involved with. But yeah, thanks, Helen. It's been really interesting.
Thank you for today.